Good afternoon, everyone. Thank you for joining us for our employment webinar today. We know that you are busy, so we appreciate you taking time to tune in and have a discussion with us about employment law issues. Please note that this webinar is being recorded and is also being broadcast live on Facebook. We hope that you are staying safe and healthy during this uncertain time. So going into the introductions, my name is Tanya Walker. I am a trial lawyer that is in my 15th year of practice. I had to pause for a moment. I can't believe the time flew by. I opened Walker Law 11 years ago with a part-time assistant, and now we have almost 10 people in our team, and 3 of them will join us today to present on employment law issues. So without further ado, let's get into the introduction of our host and panelists for today. Marley is a paralegal with our firm. She will be the host for today's webinar. Jordan focuses on employment law with Walker Law, and he will be a panelist today. And also joining him is Natasha, who is articling with our firm. I want to thank all of them for their hard work in putting this webinar together. Now I will turn this over to Marley.
Thank you, Tanya. Good afternoon, everyone. After the webinar, we will circulate an email that contains a survey. We spend a lot of time preparing for these webinars, and we want to make sure that you are getting the most benefit possible. Please fill out our survey and let us know your thoughts on the webinar. We welcome suggestions on how we can improve. During these uncertain times, we know that you are probably cooking a little bit more. So everyone who fills out the survey will be sent a Walker Law branded maple syrup. Please note that these pancakes are for illustration purposes only. They are not included. The email will also contain a link to register for our upcoming webinar. On March 23rd, Tanya Walker will present with the Canadian Bar Association on virtual hearings and remote litigation. Kindly note that this webinar is intended for lawyers. Those who participate will receive a CPD accreditation of 1 hour of substantive skills or procedural content, and half an hour of ethics, professionalism, and practice management content. We know that you are very busy and may not be able to join us for our live webcast. For those of you who were able to attend today or have missed our past webinars, you can watch them on our Walker Law YouTube channel. Please feel free to subscribe to receive up-to-date information on our videos. Moving on to today's agenda, and thank you, DF, for asking, what's on the agenda? Well, we will start with some housekeeping and provide you with some easy tips on how to use the Zoom application. We will then provide you with an update on the government's response to COVID-19. We will answer your employment law questions about COVID-19 terminations and notice period entitlements, and we will end by answering any questions that you may have. Please note that for the paralegals and lawyers in attendance today, this webinar counts towards 1 hour of substantive or procedural content to meet your CPD requirements. Moving on to the housekeeping section of this webinar. We received feedback in the past that attendees did not like that the video of the speaker is located in the upper right-hand corner of the screen and is very small. It is possible to make that video and the slideshow more proportionate. To do that, click View Options at the top of your screen and scroll to side-by-side mode. Then the slideshow will be almost the same size as the speaker's screen. Please submit your questions using the Q&A button below. We will answer all questions using the Q&A function, and we'll try to answer as many out loud as possible during the webinar. For those of you who submitted your questions when you registered, most will be answered throughout the webinar. To keep things confidential, if you submitted a question using your name, we will refer to you by your initials only. Today's webinar will feature a number of polls to increase interactivity. We include polls because we like to know what matters the most to you and where to focus our attention. So when we arrive at a poll slide, a poll menu will appear on your screen. Please submit what you believe is the correct answer. We will then share and discuss the results. Please note that those of you who are watching this webinar from a tablet or mobile device may have a different experience than those of you who are using a desktop computer or laptop. We recommend that if you can, you watch this webinar from a computer. So getting into today's roadmap, first we will ask you polls to understand your perspective. Next, we will provide the correct answer. We will then discuss and provide tips on how to protect yourself going forward. And finally, we will pause at the end to answer any questions that you have. The main objective of this webinar is to help you understand new employment laws and how to protect yourself in termination situations during the pandemic. So starting with our first poll, what employment law issue concerns you the most? Is it A, the government's response to COVID-19, B, COVID-19 related terminations, C, notice period entitlements, or D, other? If so, let us know using the Q&A.
We'll give it about 3 more seconds.
So it seems that most of you have voted B, COVID-19 related terminations. So we will make sure to spend more time on that issue. Thank you for voting. We will now provide you with an update on the government's response to COVID-19. Many of you have asked about the relevant changes to employment laws in the province and COVID-19 related legislation and obligations. Thank you for your questions. Starting with an update on the federal government, on September 27th, the Government of Canada made changes to employment insurance. The biggest change was that employees are now only required to have worked 120 hours to qualify, when previously they would have had to work 400 to 700 hours. On November 30th, the Canadian government introduced new COVID-19 benefits, including the Canadian Recovery Benefit, the Canadian Recovery Sickness Benefit, and the Canadian Recovery Caregiving Benefit. The Canadian Emergency Recovery Benefit, or CERB, was replaced by the Canadian Recovery Benefit, which provides support to those employed or self-employed individuals who do not qualify for employment insurance, but are impacted by the COVID-19 pandemic. The Canadian Recovery Sickness Benefit provides income support to employed or self-employed individuals who are unable to work because they are sick, need to self-isolate, or have underlying conditions that increase the risk of contracting the virus. The Canadian Recovery Caregiving Benefit provides support to those employed or self-employed individuals who are unable to work because they must care for a child under 12 or a family member who requires supervised care. The Canadian Emergency Wage Subsidy was extended until the summer of this year and was increased to cover 75% of employees' qualifying wages for the period of December 20th to March 13th. The CRA simplified the process for declaring work from home office expenses in 2020. The maximum deduction is $400 per person if you have worked 200 days from home last year. The Canadian government also announced that former international students who hold or have held a post-graduation work permit will have the opportunity to apply for an open work permit. Jordan will discuss this topic later in the webinar. On January 16th, the Government of Ontario extended most of the orders under the Reopening Ontario Act to February 19th, 2021. On January 12th, Ontario declared a state of emergency and a stay-at-home order. Under the stay-at-home order, persons are required to stay in their home unless they are leaving for an essential purpose, such as to pick up groceries, to exercise, for doctor's appointments, or for essential work. The government extended the maximum period related to temporary layoffs before they are deemed to be terminations under the Employment Standards Act. Under this amendment, non-unionized workers are deemed to be on job-protected infectious disease emergency leave from March 1st to July 3rd, 2021. If their employer has temporarily reduced or eliminated their hours because of COVID-19. Prior to this amendment, Temporary layoffs could last 13 weeks during any period of 20 consecutive weeks, but not more than 35 weeks in any period of 52 consecutive weeks. The Supporting Ontario's Recovery and Municipal Elections Act was passed on November 17th, which provides businesses with liability protection where customer or client contracts or is exposed to COVID-19 in their place of business, so long as they have acted in good faith to follow public health guidelines and have not done anything or failed to do something that amounts to gross negligence. Please note that this protection does not protect businesses from potential claims made by an employee against their employer. On December 8th, Bill 239, Stay Home If You Are Sick Act, had its first reading. The bill provides a framework for paid sick leave for all Ontario workers during the pandemic and beyond. Specifically, the bill would guarantee 10 personal emergency leave days per year, 7 of which would be paid. On January 19th, 11 mayors and chairs of the largest municipalities in the Greater Toronto and Hamilton area strongly encouraged the provincial government to guarantee paid sick days during the pandemic. On January 4th, the Toronto Medical Officer of Health issued a letter of instruction requiring employers permitted to be open during the lockdown to implement health measures in the workplace, including immediately informing Toronto Public Health as soon as employers become aware of 2 or more persons who test positive for COVID-19 within a 14-day period. Businesses should also be implementing prevention measures, such as ensuring hand sanitizer is provided and ensuring physical distancing takes place by at least 2 meters. Court rules have been amended to include electronic processes, including video hearings, and in response to the province's second lockdown, jury trials have been suspended until May 3rd. As of January 18th, the Small Claims Court is accepting requests to hear assessment hearings. Also, parties can now request a settlement conference with or without parties' consent, all parties' consent. So we received a question from NP which reads, can Canadians vacationing abroad claim the Canadian Recovery Sickness Benefit when they return during their mandatory quarantine? So thank you, NP, for your question. As mentioned, the purpose of the Canadian Recovery Sickness Benefit is to provide workers who are sick, must self-isolate, or have underlying conditions that would make them more susceptible to contracting the virus with a paid sick leave. Over the past month, it has been discovered that Canadians are traveling abroad and improperly claiming the Canadian Recovery Sickness Benefit when they return and are required to self-isolate. The Minister of Employment announced on January 11th that the federal government will be proposing legislation retroactive to January 3rd, 2021, that all travelers upon returning to Canada will not be eligible to receive any COVID-19 benefits during their quarantine period. Before we move on, we received a question from DM who asks, what happens when you receive a letter from the CRA asking for repayment of the Canadian Emergency Response Benefit money, also known as CERB? So thank you, DM, for your question. Before I answer this question, it is important to note that Walker Law does not practice tax law, but we can provide a brief response to this question. The Canadian government has confirmed that it is not considering letting honest but mistaken CERB applicants off the hook. If you were not entitled to CERB but received it mistakenly, you still have to repay this benefit. This is despite the admission by the CRA that there was incorrect information provided to applicants regarding the qualifying criteria. The CRA has started to issue T4 statements for the CERB recipients for the 2020 tax year. If you did not repay the amounts owed by 2020, you will owe tax on your CERB money as it is considered taxable income. Your best course of action is to repay the full amount. If you cannot repay the full amount, you can contact the CRA and inquire about how much you have to pay and whether you can implement a repayment plan to avoid a lump sum payment. So thank you to KC and AH for your questions on the impacts of COVID-19 on workplace-related legal issues. We will answer your questions in the next section of this webinar. So moving on to our first topic, COVID-19 related terminations. And for our second poll question, you are the judge. An employer terminated an employee for reasons not connected to their performance. The employee sued the employer for wrongful dismissal. The employer claimed that there were performance concerns, but that the employee was not terminated based on these concerns. When questioned out of court, the employer raised the performance concerns over 50 times. Is the employer permitted to raise these concerns as they relate to the employee's termination? Is it A, yes, B, no, C, it depends, or D, unsure? Tell us why in the Q&A.
We'll give it about 5 more seconds.
Okay, so most of you voted B, no. And then next was A, yes, followed by C, it depends, and then 15% voted D, unsure. So I will now turn the webinar over to Jordan to explain the correct answer and why. Thank you for voting.
Thank you, Marley. So it seems that about 50% of you were correct. The answer is no. Performance concerns are considered to be irrelevant when related to a without cause dismissal. Now, this was pretty much the exact scenario that was before the Ontario Superior Court in a 2020 case that was heard called Koenig versus Janssen Financial Group. So in this case, the employer terminated their employee's employment on a without cause basis, and the employee brought a lawsuit for wrongful dismissal. Now, in the employer's statement of defense, they included a number of paragraphs speaking to alleged performance concerns that they had with the employee's work. And this was despite the fact that elsewhere in the statement of defense, it was admitted that the dismissal was done on a without cause basis. At examinations, the employer also admitted that the dismissal was done without cause. However, despite all of this, when the employee was examined, the employer's lawyer asked the employee almost 50 questions relating to these alleged performance concerns. Excuse me. The employee refused to answer all of these questions on the basis that they were irrelevant. It is also worth noting that the employer at no time amended their statement of defense to state that they were alleging cause for the employee's dismissal. So what happened next was the employee brought a request to the court, which is known as a motion, asking the court to remove all paragraphs from the employer's statement of defense, which made reference to allegations of performance issues. And when the Superior Court heard this motion, they did rule that all of those paragraphs pertaining to performance concerns were indeed irrelevant, and they ordered that all those paragraphs be removed from the employer's statement of defense. Next slide, please. So we have some suggested practice tips going forward. The first thing we would say is that you should be very clear when you're terminating an employee at the outset, whether the termination is being done with or without cause. If you do have grounds for terminating an employee with cause, you should definitely go that route, because in those cases, you will not have to provide the employee with notice of their termination, payment in lieu of notice, or severance pay. However, you should keep in mind that the bar that must be met for proving that cause exists for dismissal is a very high one. It is not enough to simply raise performance issues or perhaps personality conflicts that the employee may have with their supervisors. Cause is more often found when the employee has engaged in more egregious, sometimes even criminal behavior, such as stealing from the employer or behaving in a violent or harassing manner in the workplace. So if an employer does wish to allege cause for less serious behavior, such as performance issues or some minor insubordination, the employer will have to show that there's a history of written warnings that have been given to the employee to put the employee on notice that if such behavior continues, they will be terminated without cause and won't be entitled to notice pay, or severance. So it is much more common to have a without cause dismissal, but employers should know that if you do go that route, then you will be responsible for providing the employee with notice of their dismissal or payment in lieu of notice, and in some cases, severance pay. And as we saw in this case, if you do wish to raise performance concerns or allegations of cause somewhere later down the line, you would want to make sure that you amend your defense as soon as possible, or else you will not be allowed to raise such issues. And we have a few questions before we move on. The first one is asked by both CB and MB and states, can an employee refrain from returning to the office if they feel uncomfortable? How much is the employee required to share with their employer as to the reason why they do not wish to return? Now, this question has actually been answered in some length previously by us in prior webinars and also in an article that I drafted. So we will make sure that the links to both the webinar and the article will be provided in the newsletter that will be sent out to all of today's attendees. We'll move on to the next question, which it seems quite a few of you were interested in. And that is, can my employer require me to get the COVID-19 vaccine? Well, at this point, there has not been any government announcements or any court rulings that have stated employers can force employees to receive a COVID vaccine. I would mention that there has been some precedent in the past of employees, particularly in certain industries such as frontline healthcare workers, where they have been required to get seasonal vaccines, such as the flu shot. However, there's no real precedent for what would be done in a global pandemic, since it's been 100 some odd years since the world's faced such an issue. I would mention that even if employers are not allowed to force employees to get the vaccine, the employee could still terminate an employee who refuses to get the vaccine without cause. However, if an employer does wish to do so, they should be very careful, even if they're alleging that the termination is without cause. And this is because if the employee can show that the true reason for their dismissal was their refusal to get vaccine, and particularly if they can show that their reason not to get the vaccine is tied into some sort of protected ground, such as their religious beliefs or a disability that they have, then the employer could be found to have acted in a discriminatory manner, contrary to the Human Rights Code, and the dismissal could potentially be viewed as a reprisal, which is essentially retaliation, and is something that is also seriously frowned upon by the courts, and which could subject an employer to significant liability for further damages. So if an employer does wish to institute a mandatory vaccination policy, we would say that the best practice would be to make sure that they have first instituted all other reasonable measures that they could take to prevent the spread of COVID-19 in the workplace. And in the event that they do wish to institute such a mandatory vaccination requirement, they would have to be prepared to explain why it is absolutely necessary in relation to their specific workplace, because it will be judged on a case-by-case basis, and would probably be more likely permitted in certain industries, such as frontline healthcare workers. So if you are an employer and you do wish to institute such a policy, we would certainly recommend contacting us beforehand so we can discuss the situation with you and explain any potential liability that you could be opening yourself up to. And I'll send it back to Marley briefly so she can read the next poll.
Thank you, Jordan. So moving on to our next topic, COVID-19 and notice. So you are the judge. An employee sued their employer for wrongful termination. The employee was let go without cause during the pandemic. He was 58 years old at the time of termination, held the position of vice president, and earned $100,000 per year. Is the employee entitled to a longer notice period because of the lessened job prospects during the pandemic? Is it A, yes, B, no, C, it depends, or D, unsure. Tell us why in the Q&A.
And we'll give it about 5 more seconds.
So 48% of you voted A, yes. 40% voted B, no. 12% voted C, it depends. And no one voted for unsure. So I'll now turn the webinar over to Jordan to explain the correct answer and why. Thank you for voting.
Thank you, Marley. So the correct answer is C, it depends. This is an issue that has really been subject to a great deal of interest and debate amongst employment lawyers. This case that was heard by the Superior Court in 2020, George versus Laurentian Bank Securities Incorporated, was the first case that's come before the courts in which a plaintiff alleged that he should be entitled to an increased notice period because of the economic conditions that have been created by the COVID-19 pandemic. Now, unfortunately, in this case, the court made no mention at all of this aspect of the plaintiff's argument. They instead focused on another factor, which is the character of the employee's employment. What that really means is whether the employee has any executive or managerial functions. Now, in this case, although the employee was called a vice president, it turned out that this title was really more nominal, and it was intended to provide some sort of prestige to the role. And in fact, every single employee who was in that worker's department also held the title of vice president, and none of them actually had any executive or managerial responsibilities. So character of employment is just one of what is known as the Bardell factors, which are the most commonly examined factors that courts will look at when determining what would be a reasonable notice period. Some of those factors are listed here. The first one is position, that's the character of employment. Another one, which is possibly the most important and most extensively examined by the courts, is the length of service. The longer an employee is with the company, the longer notice period they will be entitled to. Another one is age. And finally, there is the availability of similar employment having regard to the employee's experience, training, and qualifications. So it was hoped, at least among the employment law community, that the court would have weighed in this case on how COVID impacts that fourth factor, the availability of similar employment, given light to the economic climate that we're experiencing at the moment. However, as I mentioned, the court was unfortunately silent on this issue. I would mention that there is, however, case law that states that the general economic climate that exists at the time of an employee's dismissal is something that will be considered and can affect the length of the notice period that they are entitled to. More specifically, it has been held that where an employee is dismissed during a depression or a recession, that could justify their notice period being increased by up to 1/3. So we do have some suggested practice tips going forward. For employees, when negotiating the length of your notice period, and I would stop quickly and point that out, that this is something not everyone realizes. When you are terminated and you're offered a severance package or you're offered a certain amount of notice, you don't have to accept the first offer. You can always negotiate, and we would definitely recommend having an employment lawyer assist you in those negotiations. But you should keep in mind that when you are negotiating the length of your notice period, if you are being terminated in an economic climate such as the one we're experiencing now, you should make sure that your employer knows that you feel you should be entitled to a longer notice period, because it will be more difficult for you to find similar employment back out on the job market. Now, for employers, one thing they might want to consider is that generally, when you terminate an employee and you're required to give them payment in lieu of notice, That payment can be reduced by any mitigation income. And what mitigation income is, any income that the employee earns over the notice period. So if they find a new job 1 week after they're terminated, you would really only have to pay 1 week of notice, assuming that the new job paid the same salary. However, one thing you should keep in mind is that the government has enacted a number of COVID-19 specific benefits, such as the Canada Emergency Response Benefit or the Canada Recovery Benefit. Now, it is likely that any funds that the employee has received through any of these government programs, and definitely with regard to employment insurance, those can be deducted from notice pay as mitigation income. And we have a couple other questions. So the first one here is, what are employee vacation entitlements as they relate to COVID-19 and CEWS? Now, CEWS is the Canada Emergency Wage Subsidy. Now, under the CEWS, employers who have seen a drop in revenue may be eligible for a subsidy to cover part of their employees' wages. At the very highest level, employees who have seen a decrease in revenue of 70% or more can receive a subsidy through which the government will cover 75% of their employees' wages. Now, sick pay, vacation pay, and statutory holiday pay are all considered to be part of an employee's normal salary or remuneration. So they do qualify as eligible remuneration that can be subsidized under the CEWS. However, in order for such pay to be eligible for the subsidy, it must have been paid to the employee during a week that is part of the CEWS claim period. Now, excuse me, many employees pay vacation pay to their, many employers pay their employees vacation entitlement in a small portion that is provided with every single paycheck. So as long as the pay period falls within a CEWS claim period, those portions for vacation pay would be eligible for the subsidy. However, there are some employers who pay their employees vacation pay in a lump sum, either at the end of the year or perhaps every few months. So in those cases, the lump sum payments in their entirety will not be eligible for the subsidy. Only the portion of the lump sum that was paid for vacation pay earned during a CEWS claim period would be eligible. And now we have another question from SF. And this states, how does hiring someone in Canada on a school visa work? What happens when their school visa expires? Well, thank you for your question. I would definitely, first of all, preface this by stating that we do not practice immigration law at Walker Law, but we will provide you with a brief answer that I hope is helpful. So there are certain eligibility requirements that student visa holders who wish to stay in Canada and work off campus will be subjected to if they do not have a separate work visa. And these include that their student program must have already started. They must be a full-time student at a post-secondary institution that hosts international students. If they are not enrolled in full-time studies, the reason for that must be that they're only studying part-time because they're in their final semester, and in their previous semesters leading up to the final semester, they did have a full caseload. They must also have a valid social insurance number, and the study program that they're enrolled in must be at least 6 months long, and it must lead to the issuance of a degree, a diploma, or a certificate. Now, people who qualify for this can work up to 20 hours a week during the regular school year or regularly scheduled breaks. Now, when a student visa expires and the holder wishes to remain in Canada and keep working, they can do so provided that they have applied for a work permit prior to their student program ending, or they can be given up to 90 days after receiving their final grades in order to apply for a postgraduate work permit. Now, a postgraduate work permit allows the holder to remain in Canada and work full-time for up to 3 years. And in order to be eligible, they must have continuously studied full-time in Canada and have completed a program of study that was at least 8 months in duration. Another thing that Marley mentioned briefly in the legislative update section is that the federal government did make a new announcement on January 8th, stating that foreign nationals in Canada who have been affected by the pandemic and who hold either an expired or expiring work permit can apply for another permit that will be valid for further 18 months. And they will be allowed to remain in Canada and work for the duration of that permit's validity. So Marley will now take over and we'll present our next poll.
Thank you, Jordan. So moving on to our next topic, failing to follow COVID-19 protocols. So you are the judge. An employer created a policy in response to COVID-19. All employees were trained on the policy and it was clearly worded. According to the policy, employees waiting for the results of a COVID-19 test were required to self-isolate and were not to come to work. While waiting for the results, an employee came to work and tested positive for COVID-19 2 days later. Was the employer justified in terminating the employee? Was it A, yes, B, no, C, it depends, or D, unsure? Tell us why in the Q&A.
We'll give it about 5 more seconds, Marley.
Okay, so 42% of you answered A, yes, 21% answered B, no, 38% answered C, it depends, and no one voted for unsure. Thank you for voting. I'll now turn the webinar over to Natasha to explain the correct answer and why.
Thanks, Marley. For those of you who answered C, it depends, that's the correct answer, and I will now explain why. So a very similar situation happened in a recent case called Garda Security Screening, which involved a union, but the principles can be applied to any workplace. So in March 2020, at the beginning of the COVID-19 pandemic, the employer, Garda, communicated a COVID-19 policy to all of its employees, which was in line with public health measures at that time. This policy was meant to prevent the spread of COVID-19 in the workplace. So under this policy, employees who are awaiting the results of a COVID-19 test were clearly told to isolate themselves and to not attend work. All employees were made aware of this requirement. On April 12th, an employee informed Garda that she had tested positive, and she was asked to prepare a written statement of her actions leading up to this test result. The employee reported to the employer that she went for a test on the 6th of April and that she did not attend work on that day or the following 2 days, and that Garda had never informed her of this self-isolation requirement. Garda, of course, investigated, and then they discovered that the employee did attend work on the same date that she was tested and was dishonest about this. Garda terminated this employee because of the violation of their COVID-19 policy and due to the fact that by doing this, she had put her employees and the public at risk. So it went to arbitration, and in this case, the arbitrator did uphold this termination, stating that Garda had taken all necessary actions to ensure that its employees were made aware of this in policy. The policy was clear, it was not ambiguous, and that this was serious misconduct on the part of the employee. So the answer was, it depends for our poll question, because in other cases, this kind of termination may not be upheld by a judge. As Jordan stated earlier in this webinar, with cause terminations, it's a very high bar. So some suggestions we have for employers going forward to avoid the situation in Garda is to first train your employee on your pandemic policy, have them sign off, and then place this signed document in their employee file. So this will serve as a written record that the employee was made aware of the policy and that they understood the consequences of breaching your policy, where the consequence may be discipline or termination. And this is in the event that you terminate your employee and then they potentially bring a wrongful dismissal claim against you. Our second suggestion is that you should also implement a COVID-19 symptom screening measure to be enacted before any employee enters the workplace. So this will also serve as a written record in case you as the employer need to investigate any positive cases that turn up in your workplace. So as Jordan said, if you believe that you have grounds to terminate an employee based on a breach of your COVID-19 policy, contact our firm first to ensure that you're on the right side of the law. So we have a question from CH. Thanks for your question. And they want to know about WSIB, which is the Workplace Safety and Insurance Board, and terminations for injured employers. So I will preface my answer by saying that at Walker Law, we do not practice WSIB law, but I can provide a general answer to your question. So under Ontario law, if you're injured, you can't work, and you're claiming workers' compensation and medical benefits from your employer, you cannot be terminated because of your injury. So under the Ontario Human Rights Act, an employer must accommodate your medical condition up to a limit. And this limit is where it would cause undue hardship to your employer to accommodate you, or if your condition makes it unlikely that you have any reasonable prospect of returning to your position. So as is the case with cause terminations, this limit is also a high bar for your employer to meet. And this is especially so if you were not consulted before you were terminated. Tanya did speak about the duty to accommodate in our last employment webinar, which took place on the 20th of August. You can find that on our YouTube channel around the 50-minute mark. So again, to reiterate, if you're terminated due to your injury or condition, you may be able to bring a wrongful dismissal claim against your employer. Additionally, some employers have reemployment obligations as set out in the Workplace Safety and Insurance Act. So under this act, when an injured worker is medically able to return to their pre-injury position or can perform suitable work, the employer must offer either the pre-injury position, a comparable position, or suitable work. So if the worker is terminated within 6 months of reemployment, the WSIB presumes that the employer has not fulfilled their reemployment obligations under the statute. If this presumption is not disproved, the consequence may be a levy against the employer. So I'll now turn it back over to Marley to introduce our next topic.
Thank you, Natasha. So our next and final topic is notice period entitlements. So this, our fifth poll, will be our last poll. You are the judge. When an employee was hired, he was entitled to a discount of stocks for the company. The employer never explained this to him and was directed to read a lengthy and complex agreement. It stated that the stock options terminated if the employee was let go. After 23 years of service, the employee was terminated without cause. Will you uphold the stock option paragraph? A, yes. B, no. C, it depends. Or D, unsure.
We'll give it about 5 more seconds.
Okay, so 26% of you voted A, yes. 44% voted B, no. 30% voted C, it depends. I'll now turn the webinar back over to Jordan to explain the correct answer and why. Thank you for voting.
Thanks again, Marley. It seems the most popular answer was the correct one. The answer is B, no. So the scenario that was just included in our poll is very similar to the situation that was before the Ontario Superior Court in a case last year called Battison versus Microsoft Canada Incorporated. So in that case, an employee was terminated after 23 years of working for Microsoft. And he sued Microsoft for, among other things, the unvested stock options he held that would have vested during his reasonable notice period. Now, during his employment, he was granted stock options annually, and every year when he received his stock options, he was directed to review the stock option agreement, and he was also asked to complete an acceptance form that indicated that he had read, understood, and agreed with the terms of the agreement. Now, this acceptance form was all done online. It really just required the employee to click off a box stating that he read, understood, and agreed with the agreement. The agreement included a termination provision that specified that any unvested stock options that the employee held would also terminate at the time of his employment's termination. Now, the plaintiff testified that although he had always clicked off that box indicating that he had read, understood, and agreed with the agreement, he had never actually read the full stock option agreement. And Microsoft had never drawn his attention specifically to that termination provision. So when the court heard this case, they held that the clause would not be upheld because Microsoft did not specifically direct him to the termination provision, which the court found to be harsh and oppressive. The court also found that simply telling the employee to read the agreement would not be enough to make the clause upheld. So there's another case that was also heard last year, but this one was heard by the Supreme Court of Canada, which is the highest court in our country. That was called Matthews versus Ocean Nutrition Limited. Now, in this case, the Supreme Court clarified the test for determining whether bonus payments and benefits and other entitlements should be included in damages that an employee receives during their reasonable notice period. So essentially, the court found that the test is if the employer wants to limit the entitlements the employee would be entitled to receive during their notice period, they must use very clear and unambiguous language to do so. So when such cases arise, the court will examine a couple factors. The first is, would the employee have been entitled to receive these benefits or bonuses during that time period if their employment had not been terminated? And the second thing they look at is whether the terms of the employment contract or a bonus plan or benefit package unambiguously took away or limited their right to receive these entitlements during a reasonable notice period after being terminated. So in that case, the court did not provide any specific examples of what language would be good enough to limit such entitlements. So as such, any employer who wishes to do so should really strive to make any such language they use as clear and unambiguous as they possibly can. We do have a few suggested practice tips going forward. If you do want an employee's entitlements to terminate upon their termination and not to continue through their reasonable notice period, you should make sure you take the time to highlight and draw the employee's attention to any specific paragraphs that do so. And of course, those paragraphs should be drafted clearly and unambiguously. One little tip I would suggest is that rather than just have a signature page at the very end of the agreement where the employee signs off on, if there are any clauses that could significantly limit their entitlements, you might want to either have a space for them to initial right next to that paragraph, or maybe even have another paragraph below the limiting clause that states, I have read, understand, and agree with the clause above, and have the employee sign there, as well as at the end of the contract. So as we saw in the Microsoft case, the court will not allow employers to place the burden on the employee to read a lengthy and complex paragraph or agreement. And another good tip would be, if you do wish to limit such entitlements upon termination, make sure that that is set out at the very beginning of the employment relationship and included and clearly and unambiguously explained in the very employment contract. So we do have one more question before we end, and this one comes from D.O., who asks, what elements distinguish an employee from an independent contractor? Is there any recent case law that clarifies this distinction? Now, I would mention that there really isn't any recent case law that clarifies this distinction. This is an issue that's fairly well settled in our law. It's dealt with all the time, and it has been for years. I would mention that we went into this topic in some detail in our July 9th, 2020 employment webinar at the 49-minute and 25-second mark. The link to that YouTube video is posted right here. But I will just give a very brief answer of what distinguishes an employee from an independent contractor. One, an employee is generally one who has all of their tools and materials for completing their job provided by the employer, whereas an independent contractor would supply their own tools and materials. An employee generally works exclusively for just one company, while an independent contractor is free to contract and do work for as many companies as they like. An employee is paid a specific salary or wage, while an independent contractor receives a fee that is specific to the contract and also to the project that they are being hired for. An employee, perhaps most importantly, will be entitled to statutory benefits, and when they're terminated, they're entitled to notice, assuming it's without cause, or payment in lieu of notice, and in some cases, severance. Whereas an independent contractor is not entitled to any of those benefits. I should briefly mention that there is another intermediate category known as a dependent contractor that sort of falls in the middle. And dependent contractors are not considered employees, but they are entitled to notice and possibly severance on termination of their working relationship if it's without cause. So business, excuse me. So business owners should be aware of this category. And again, dependent contractors are described in some length in the link above this chart here. So now I will hand things over to Tanya for some closing remarks.
Hi, before I close, Jordan, there was a question that was asked earlier, and I'm wondering if you might know the answer. Someone asked, can I hire a nanny whose work permit expired? So I would think that you really can't hire somebody whose work permit has expired legally. What do you think, Jordan?
I would agree with you. And again, as I mentioned, we're not immigration lawyers here. We are employment lawyers. But I did mention in that the section about student visas that the government has announced that people who have expired or expiring work permits can apply for another work permit that will make them eligible to work for another 18 months. So while I certainly wouldn't recommend hiring somebody whose work permit is expired, I would recommend informing them of the option to apply for another one that would allow them to work for 18 months and not to hire them until they have applied for and received the extended work permit.
But would it be okay, do you think, if the person was hired during that process of having that application reviewed?
If they had a previously valid work permit that expired during COVID, I think there may be some exceptions, but again, I can't give any concrete advice either way. I would have to look into it, and I'd be happy to send an email to the person who asked that question and let them know what I find out.
Well, thank you, Jordan. So this ends our webinar. If you have any questions, please feel free to jot it in the Q&A box. And I just wanted to say thank you to everyone, especially the panelists and the host, Marley, for your hard work putting this webinar together. The law is constantly changing pretty much every day, and it's quite a challenge to keep up with it. I want to thank you for taking time out of your busy schedules to meet with us today. It must be difficult balancing work or childcare or care of anyone else, including yourself. Thank you all for joining us, and I hope that you continue to stay safe and healthy. Have a great day, everyone.